Judge Freeman, in short, said, yes, Mr. Wilson, you did everything that you were legally supposed to do. You followed the rules of procedure, the rules of law. You followed the method by which is acceptable in our society when you have a tort against someone. And when someone's trying to execute something on you legally, you defended yourself like an attorney. Although you're not an attorney, you've handled yourself extremely well in court. That being said, the laws of Florida, constitutional homestead laws, are in your favor. We got that. We understand that a judgment was executed on against your property, your homestead property, and you contested that judgment. You filed a 1540 motion to set aside that judgment as being void. We see that. That's been scheduled in my court. And as you well know, I put that in recess because the actual pleadings was in another judge court, Judge Lisa Walsh. And as you well know, I cannot hear a matter that's before another judge. So we're done here on that 1540, setting aside the Sharma judgment against you that Mr. Stuart Cowell possessed until such time as you have that case, Creole LLC versus American Investment Services, transferred to my division. We can't speak on that, the validity of that judgment. Now, what's before us is your homestead declaration, where you're claiming homestead protection based upon the evidence, based upon the fact, based on the court record that reflects the property as your homestead. Now, you've laid out all the particulars and you've articulated the state statute and the Constitution that supports your position very well. But I'm sorry, unfortunately, I got news for you. We're going to do an about face on the standard rules of civil procedure. We're going to do about face on your due process rights. We're not going to follow the rules of engagement. We're going to discard our oath of office just one time. And we're going to give the judgment creditor, even though the Constitution of Florida says that prohibited. We're going to ignore that and give Stuart R. Cowell your homestead property. We're going to say that you abandoned it, even though it was my order that told you to get off the property. Even though you submitted that order to me, I did not put it in the record. At the time, I didn't have a clerk of court. But I saw the order that I wrote and signed off on in 2010, telling you and the public to get off the property, while Miami-Dade County does this unsafe structure inspection, and you can't be there. I see that. But now I'm going to execute another order. Quite frankly, I should have recused myself, but I did. And so now I'm going to write an order in favor of the judgment creditor that says that you abandoned the property, when in fact I ordered you off the property. And then on top of that, I'm going to say that you waived your homestead right. The Constitution says there are only specific ways to do that. There's nothing in the record to show that you waived it. There's been some incidents of an accident, of an unintentional transfer that has occurred on the property, but it's been put back in your name once that error was detected. So the intent to leave the property as your homestead never was a fact. You've always had intent. You've lived there. You stayed there until Stuart Cowell and Roniel Rodriguez had you removed by the sheriff. That being said, we're not going to uphold Florida statute or the Constitution on the homestead matter. We're going to say that you waived your right to the homestead protection and that you abandoned the homestead. I'm going to do a little something else. I'm going to do something unusual. I told you in another proceeding that I cannot hear a matter that before another judge, and that's true, I can't. But I'm going to go ahead and include in this homestead order that matter, even though there's been no hearing on it, and I certainly don't have any particulars that would justify my action. I'm going to go ahead and say that the judgment is valid and it was not the product of fraud. I have no way of knowing that, but you know what I was basically influenced to do that. And so in addition to you allegedly abandoned your homestead rights, your $2.5 million piece of property, the only one that you own, the only home that you have in the whole state of Florida, you abandoned, I guess, to walk and live in the streets, I don't know, and you waived your homestead right. And so to make this one kill-all done deal, I'm going to deny you an opportunity to be heard on the 1540 motion to set aside the very judgment Stuart R. Cowell and Roniel Rodriguez are using to take your property. I'm going to go ahead and say that the judgment is valid and it's not the product of fraud. And so there now you've lost everything. And now I'm going to retire as a judge in honor after I violated my oath of office, taking your property and giving it to the judgment creditors against Florida Constitution, against stare decisis, against district court's rulings on homestead, against district court ruling on unlicensed contracting in the state of Florida, against the Supreme Court rulings on unlicensed contractors in the state of Florida. Because I am Jill Freeman. I am a circuit court judge at the 11th Circuit in and for Miami-Dade County. I'm white and you're still black. And so we're taking your property, and have a nice day.